Hi there, I'm Seb Maley from Qdos, and in this video we'll take a look at the latest in an increasingly long line of IR35 cases involving TV personalities. This particular case is a first-tier tax tribunal involving the TV and radio presenter Adrian Chiles and his limited company Basic Broadcasting Ltd. Mr. Chiles is well known for presenting football shows on both the BBC and ITV, but also a wide range of other entertainment and current affairs programmes. So this case was actually first heard at tribunal in 2019, but the original judge sadly caught COVID before a decision was made, and the effects of long COVID meant that she was unable to return to work. This meant that the case had to be partially reheard, and that didn't happen for another 2 years. The tribunal system is slow at the best of times, but because of that unfortunate turn of events, this case goes way beyond even the normal lengthy timescales. The result was finally released in February, and thankfully for Mr. Chiles, the new judge agreed with him that the engagements were outside IR35. As I mentioned earlier, HMRC have been very aggressive in targeting high-profile personalities with IR35 in recent years. In fact, if we look at the last 5 years of IR35 tribunal hearings, there have been 14 cases in total, and 9 of them have involved TV or radio presenters. Including Adrian Chiles' case, 4 of them have been won by the presenters and 5 by HMRC. With Mr. Chiles, HMRC were targeting a 5-year period between 2012 and 2017, incorporating engagements with both the BBC and ITV, which HMRC argued were all caught by IR35. The total tax and national insurance at stake was just over £1.7 million, and because the tax years were prior to the reform to IR35 in either the public or the private sector, that liability sits squarely with Mr. Chiles. Perhaps because there were 2 different judges attached to the case, the decision notes are incredibly lengthy, and it's clear that both judges did a huge amount of work in ensuring that all of the facts were covered and considered. As with all status cases, the judge considers the facts of the case and sets them against the principles established by case law over the last 50 years or so. The foundation for these was a 1968 case involving a company called Ready Mixed Concrete, which is where the well-known factors such as control, substitution and mutuality of obligation were cemented, no pun intended, into status decisions. Unsurprisingly, there are a lot of people who say, fairly in my opinion, that using a case from 1968 to determine a modern worker's employment status isn't a particularly progressive way of doing things, but that's an aside, and there's no sign of that changing anytime soon. What the findings of this case really remind us of is that determining IR35 status should never be a checkbox exercise, but it's vital to look at things in the round. The judge found that Mr. Chiles didn't have a right of substitution, was subject to a framework of control in what he did, and also that there was a mutuality of obligation present in the engagement. So on the face of it, not a particularly strong argument for being self-employed. However, the judge was also convinced that Mr. Chiles was in business on his own account. He had multiple engagements outside of his contracts with the BBC and ITV. He also paid his agent 15% of all of his income, and he employed a personal assistant directly. Having stepped back to look at the facts in their entirety, the judge upheld Mr. Chiles' appeal and agreed that he was not a disguised employee. So after what must have been a painful and stressful wait, it must have come as a huge relief to Mr. Chiles and his advisors. There are, however, a couple of important footnotes to this case. Firstly, because it was just a first-tier tribunal, none of this will set any legal precedent, so contractors won't be able to use any of the judge's decisions in bolstering their arguments. Secondly, and more importantly for Mr. Chiles, it is highly likely that HMRC will appeal this case, which means this is probably going to roll on for some time. If they do appeal, it will go to an upper tribunal for the judge's decision to be analysed and either upheld or overturned. Beyond that, it can proceed to the Court of Appeal if either side are unhappy with the upper tribunal's decision. Still, it can be considered a victory for the taxpayer and a reminder that operating outside I-35 is an entirely valid and legitimate way of working across a variety of spectrums. We'll naturally keep you fully updated with any further developments with this case. Please subscribe to our channel for more regular updates. Thanks for watching, and we'll see you again soon.